132, Rivera versus Montefiore Medical Center.
May it please the court, my name is Brian Shute. I represent the plaintiff appellant here. As you know from the briefs,
Excuse me, counsel, would you like to reserve? Please proceed.
as you know from the briefs, this is a case in which defendant Montefiore was allowed, over the plaintiff's strenuous objection, to produce proof to the effect that the 44-year-old man, whom the medical examiner had said died of bronchopneumonia, in fact died of a heart attack.
Mr. Shute, why didn't plaintiff's counsel object to the insufficiency of the 3101D response when it was received or shortly thereafter?
Your Honor, this is an interesting point. And the lesson here is, I think, from the appellate division majority decision, that if you want to get down, the way to avoid the medical exchange rule, the expert exchange rule, is to exchange even less. If, for example, the distinction I'm getting at is there's a distinction where a claim is made, and now the recipient knows that there's detail lacking, that for example, the defendant violated the rules and regulations, or that the defendant complied with the standards of care. And now the other side knows, okay, what rules and regulations? Please tell me. And can ask for greater detail. But when the whole subject at all, there's nothing on it. The example I have in my brief is, for example, where the plaintiff provides a very detailed listing of what the defendant did wrong on January 1st, and nothing at all as to what the defendant did wrong on January 3rd. But maybe ends with, and he'll testify, the expert or she'll testify as to negligence and causation. Ends with something like that. And then the argument is, well, I didn't say, as Justice Ahrens pointed out, you didn't say that you would not adduce testimony as to something that occurred on January 3rd, and you left something at the end, which Mr. Simone called in the appellate division a non-committal. We'll talk about causation. Now, if that was the rule, Judge, if that was the party now has to move, whenever you find an opening.
But, Counselor, let's assume for the moment that this was an obvious insufficiency. It mentions causation, but it says nothing about what the causation is. What if it's not so obvious? What if it's a closer case? Isn't it up to the opposing party to say, I don't think you gave me enough detail? And then that can be addressed. Either the disclosing party can say, oh, yes, I think I did, or, okay, I'll give you more. I mean, isn't that the whole purpose of this, so that it's not a guessing game on either side?
Well, it shouldn't be a guessing game on either side. I grant you, Judge, that there's no bright line here. We're talking about a continuum. And we could change the hypotheticals and change them, so you give more and more notice that something's lacking.
But isn't these medical malpractice cases are read unto themselves, right? Quite often the plaintiff, and I think it happened in this case, calls the defendant doctor, or the doctor for the defendant, and the strategy is you want to freeze that testimony so that that testimony doesn't get fashioned to respond to your expert. So you put him or her on first, then you have your expert testify. And that's why it seems to me when the 3101D comes in from the defense, they always have that catch-all in the bottom that is objectionable, pardon me, from your point of view. But what happened here, it seems to me, and I don't know if you're going to address timeliness, is there was a timely objection after he testifies on cross-examination to his own lawyer, what happened. That caught, it seems to me, the plaintiffs by surprise. And then they want a more specific, and it seemed to me they were entitled to it. But the judge said it was untimely when they made that objection. Right? Am I misreading the record?
Correct, Your Honor.
Okay.
I agree with part of that. I'm sorry.
Why didn't plaintiff's counsel just ask for more time? Usually that would be the solution here. See, your abuse of discretion argument, I think, would have more validity and more force if the alternative was not, if the court says it was untimely, okay, that's a difficult point for us to argument. And it's also difficult to argument that there is no theory of negligence or of causation presented in the initial disclosure. Those are two, seem to me, clear points in the record. But why didn't they just
Judge,
ask
let
for
me
more time?
answer that, and I think Judge Stein's question as well, because I think they go together.
I want you to answer this question. I want you to answer the question, did they ask for more time, and was it a conscious decision or just one that was made in the moment?
The answer to that first question is no, they did not, and the answer to the second question is I don't know whether it was conscious or unconscious. It's not in the record. But the gist of your question, why shouldn't the attorney have to ask for more time, is, I think, goes along with Judge Stein's question and goes along with the purpose of the statute. One purpose of the statute, I mean, back in the day, it was very fair. Ambush, that's the way we had it. Any side could ambush the other. That was fair. The idea of this statute was that, number one, the legislature thought, by disclosing the expert testimony in advance of the trial, each side gets a better feel for the merits of their case. That's number one. But number two, Your Honor, and there was a second purpose, not just to move cases, but also to decide them correctly. The whole basis of our civil justice system is we think and we hope, in an adversarial system, that if each side gets a chance, a fair chance, the right side will win at least enough, a higher percentage of the time to make the system work.
But that's my point. If you had brought this to the fore when it first got to you, then the pursuit of justice would have been furthered because it either would have been corrected or somebody would have made a determination that it didn't need to be. So
Not only, Judge, was there no reason for anyone reading through this to guess, oh, they're contesting the cause of death, much less they're claiming it's a heart attack. I suggest to you, Your Honors, that at the beginning of trial, defendant didn't even start with that theory.
But counsel, the notice actually says possible causes of the decedent's injuries and contributing factors, right? I mean, doesn't that put you on some notice that they're not agreeing with your cause of death, or at least it's vague enough that they might leave themselves room not to?
No,
You're
Your
going
Honor.
to testify on the issue of proximate causation, on the issue of causation, and the possible causes of injuries.
What one expects from that is exactly what happened in the defense
Oh, I
opening
know you're
here.
going to say you expect them to agree with the autopsy, but that doesn't say
No,
that.
what I'm getting at, what one expects from that caveat, we're going to talk about causation, is exactly what you have at page 103, the defense opening. They tried to bring him back, they couldn't bring him back, tragedy, terrible tragedy. It can happen with patients that have pneumonia. Yes, 90% of someone, he meant 9% of someone dying with patients that have pneumonia. Sometimes you do all the right things and they may not respond. Now that's an attorney talking about causation. We had no objection to that, and that was encompassed by their notice. But how can one possibly know in a case where someone is admitted to a hospital with a diagnosis of pneumonia, they can't breathe even with oxygen? They're repeatedly throughout the night noted to have shortness of breath, and then they die, according to the medical examiner, of bronchopneumonia. How could one suspect that this is their theory, or know that something's being withheld?
Well, okay, we can, I take your point on that causation issue, but to go back to what Judge Fahey said earlier, isn't our standard of review abuse of discretion here? So the judge would have been perfectly okay to say they were precluding this testimony, and we would have reviewed that on an abuse of discretion, but they didn't. So aren't we reviewing that decision also on an abuse of discretion standard, given what had happened in the course of this trial, namely the testimony that had already come out at that point, the fact that there is no request for an adjournment, and we're looking back now and saying it was an abuse of discretion as a matter of law to let this testimony in?
3 points on that, Your Honor. This court has never interpreted this statute. There is no Court of Appeals decision for the lower courts to look for guidance. It doesn't exist. Number two,
On what point?
construing 301D and what kind of specificity need be given, and what to do in a situation like this. This court has never construed the
Is that
statute.
the issue here? Is the issue here, was the notice sufficient, or is the issue here whether or not the judge should have let the testimony in?
Well, yes, the issue is whether the judge should let the testimony, but understand, in this case, there is no claim that we did provide notice. There is no claim that this is something the plaintiff could have gotten from some other record in the case, should have known. There's no thing about a heart attack in any record one could have looked at. And
So the rule should be that when you disclose, you have to tell us what your theory of causation is then.
the rule is you should disclose such amount of evidence so that the other party is not surprised or taken by ambush.
Well, the question to me is not whether that should be the rule. I think that is the rule. The question is who has to do what when if that isn't fulfilled to the other side's satisfaction.
As to those 2 points, in my brief, I quote Professor Pat Connors, his commentary on the statute, where he says all this case law, there's tons of case law, just none from this court, suffers from, he says, corpus juris secundum syndrome. You can find a case for anything, according to him, from the appellate division cases to which this court has never spoken. And what we don't want to do, I'm suggesting, Judge Stein, is end up in a system where a process that was supposed to streamline cases and make them move faster, as well as end better, the side that deserves to win wins more often than not. What we don't want to do is have that create a volume of motion practice, because I suggest to you that if you have to make a motion whenever there's a clause which can later be claimed a reservation of rights, that's every case, and that's every time. It will be the 5th time they come back. There'll always be some phrase which can later be said to be a reservation of rights, and why did you accept this last version, the 4th version, the 5th version? And motion practice is not what you want to create, I'm suggesting.
Thank you,
Thank
Mr.
you.
Shute. Counsel?
Good afternoon. Christopher Simone for the respondents. I think that the issue here is, the overarching issue here is whether the trial court abuses discretion as a matter of law. And I think it's important to understand how the plaintiff's argument has somewhat shifted from an insufficiency argument to a misleading argument, because they're two different ways to look at it.
Well, do you concede that it was insufficient?
I don't think it was insufficient to the extent of, I mean,
If you were on the other side of the fence there, you wouldn't say, what? You're telling me you're going to discuss causation. What causation?
well, I think the point was made before that it says, causes of death and contributing factors. That, to me, says they're obviously not agreeing with an autopsy, which every attorney should know is not.
But if you're trying to prepare your case, don't you want to know, and don't you think that the statute requires that you
Yes.
tell me what your expert is going to
Yes, and if I received one that I thought was insufficient, I would immediately make an objection. They did that in this case with respect to Dr. Silverman's qualifications, and that was remedied.
Does that have to be a motion?
No, it doesn't have to be a motion.
No, it can
Attorneys
be a
get things-
conference, right?
Yes, you can just write a letter. And most of the time, I think collegiality, I think attorneys, they provide that information, because, as long as you make the objection, I think you preserved your complaint about it. Then it becomes the onus on the other party. They may be
Or you
risking.
come into the trial part on conference
And then
day
get
and you
it,
raise it.
and then get it precluded on that basis. But it's not uncommon for an attorney to get a document, whatever it is, 3101D or whatever, and see that it's insufficient, say, I better
Yeah, but this
lodge
is
an
different.
objection.
The key here, it seemed to me, as Judge Gonzalez said in his dissent, was you've got a doctor who says, I don't know what he died of. I think it was probably, something, but I don't know what. And miracle of miracles, 2 months later, when he's, I'm going to suggest, prepared for trial, he then on cross-examination says he died of a heart attack, and that wasn't made clear to anybody at any time. It wasn't in the disclosure, and I get the cowcatcher wording at the bottom of these, because you honestly don't know everything that's going to come out. But when it's there, I mean, didn't you have an obligation to say that the ER doctor is going to testify that he died of a heart attack, because that's what he told us?
Well, everybody, I think it's the sudden arrhythmia, to be specific, is the issue. But that's what you talk to your expert about. I mean,
No, this is a fact witness, as Gonzalez said, and you knew, or should have known, I realize these things are tough sometimes,
You can say
that he was going to testify that the death was not as a result of the pneumonia, but was a result of, let me stick with my heart attack,
Right.
it's easier to say than arrhythmia. But you didn't disclose that, and they had no way of knowing that could have been a part. They could have been satisfied with your disclosure because of what you said, but you had knowledge that the argument is, should have put in a 3101D or a supplemental, that you did not. And then when they found out about it and made an application to the court said, well, you're untimely.
well, I think they did have notice, and I'll tell you why. The other argument that is, it's not only the insufficiency, but it's also the speculation, okay, of the theory. And just so it's clear what plaintiff's objection was, on page 762, he summed it up to the court, 2 points. One, is the 3101D wasn't specific enough, and two, that it's an improper question to ask an expert, do you have an opinion as to what the possible cause of death was, other than what's stated in the objective autopsy? Well, it's not improper to ask an expert whether...
No, is it? Well, I don't know.
No, but the reason that...
Pardon me, let me finish my thought. I don't know what 762 is. Is this after the ER doctor testifies that he died of arrhythmia, or is it before that? Because my sense of the record was this was a surprise. And it was a surprise brought on by the defendants who had been called in the plaintiff's case in these things.
Well, one...
Cross-examination.
Dr. Mukherjee was the ER doctor
Yeah.
plaintiff called. The next witness on this subject was their expert, Dr. Schiffer. The
Right.
objection was made after those two witnesses.
Right.
After plaintiff's expert conceded it's possible.
But in the middle, in the middle of the trial is my point. And
Right, but
and the doctor said, the judge said that's untimely. I'm not sure that's untimely. That's what I'm kind of driving at.
Well, I'll tell you why it's untimely, and it's important to understand that the issue is insufficiency, not misleading. We didn't say theory A and then present theory B. If it's insufficient, well, it goes back to your earlier question, were they on notice? Yes. And the reason they were on notice was the court also found that the testimony by Silberman was not speculative because there was a clinical presentation here. You know, a pathology report on an autopsy is a gross pathology of whatever they're examining.
Doesn't the
But this is
notice issue
clinical.
go back to the 3101D notice, not the notice of what testimony was given at trial?
Well, it said contributing factors, so you're on notice that, hey, what was the clinical presentation here? Because
No, but
the
see, what
autopsy
you're,
have been
well,
wrong.
I hate to interrupt you on that, but let's forget, or you can include what the autopsy said. You're saying, it says various things.
Right.
Right, but you've got a legal requirement to disclose what your experts are going to say, and your experts ultimately said heart attack, and that was not in the 3101D. And they objected, and they said it was untimely. I keep going back to this untimely, because I think in the middle of a trial, depending on the facts, it may not be untimely. And whether this one is one or not, I don't know.
Well, I don't think it was untimely. I think it was untimely in the sense that you could have examined what contributing factors could have caused this with your own expert, who ultimately
You've got to
agreed with us.
disclose. This is my
Right.
point.
But that's what the notice
I'm
was.
not going to talk to my expert. I'm not going to talk to anybody. I'm just going to go in and wing it. I can do that as a lawyer, all right? But you have an obligation as a defense lawyer, and one of them is to say he died from a car accident, he didn't die from a gunshot. And you can't go in the middle of the trial and say, it wasn't a gunshot, it was a car accident, and say, well, even though we didn't disclose that, it's untimely for him to now complain about that.
Well, we didn't, that's a misleading theory. This is an
Well, I know.
insufficiency theory. That's why I was trying to make a distinction. It's different. If it's insufficient, object to it. Otherwise, presumably, you've done your homework and you know what those theories can be, because we elicited this information from their own expert. Why didn't they elicit this
But the
information? in prepping
statute
the case?
says reasonable detail,
Right.
right? Okay. So let's assume for the moment that what your expert said here was not reasonable detail. So doesn't that sort of encourage gamesmanship for you to do that and require the other side to come back every time and say, well, we don't think this is reasonable?
I think reasonable minds can differ on what's reasonable.
But,
That's for
No
sure.
pun intended,
I
but,
agree.
but the issue here is still, was the court's decision.
Well,
That it was
is
untimely
your
and abuse of
position, if he
discretion.
had raised an issue about this, you would have said, I don't have to give any more detail? When you say
Well,
reasonable minds can differ, is it your position that you would not have had to have given more detail if he had requested it?
I don't know what we would have done, but we addressed the other objection, and we addressed it to the plaintiff's satisfaction. So if somebody had requested it, I think generally we do provide more information. So my answer to that would be, if somebody requested it, we would have done it. I mean, we don't generally engage in a lot of this motion practice. We generally do it, it is an adversarial system, but it doesn't mean there's not.
And is it your position that your expert really did not know what causation theory he was going to give until he heard until the other testimony from Dr., I can't remember how his name is pronounced,
Mukherjee,
testified?
and then Dr. Schiffer is the
Yeah.
plaintiff's expert.
Yeah.
I don't know what Dr. Silberman knew, but I know that.
You were going to have him as an expert, you didn't know?
I personally, I don't know. I don't know what he knew, but that doesn't mean that it wasn't reasonable detail in the 3101D. But in any event, we certainly have the right to explore an issue with our expert that was addressed by plaintiff. Remember, they never objected to the testimony or moved to strike the testimony from the other two witnesses. And this whole appeal
Well,
is
their
revolving
witness-
around the
your-
zero.
Their
payment
witness,
settlement.
you're not quite presenting accurately that testimony, right? Because their other expert witness says, well, anything's possible. But then goes on to say that the record, the medical records and so forth, did not support that this was caused, death was caused by an arrhythmia, right?
He agreed with.
No, is that true?
No, that's not true.
That's
because-
not true. Why is it not true?
Because he didn't say anything he said that one place, but it's a long exchange and a long questioning. And he ultimately agreed that if he had all these symptoms, this clinical presentation, that he could have died of a sudden arrhythmia. He agreed with that. So it wasn't just that one phrase, anything is possible. It was
Counsel,
more than that.
was Dr.
Mukherjee.
Mukherjee, was he the plaintiff's witness, or was he defendant's
He
witness?
was plaintiff's witness.
He was plaintiff's
He was
witness.
the ER doctor.
He was the ER doc, and so the defendant didn't object to him opining on how the decedent died, because the issue is whether he was a fact witness or not.
Right.
So they called him as a fact witness, but somehow he made an opinion about causation of death.
Right. He was
And you
asked-
didn't
he was
object
asked.
to it.
Well, we didn't object to it.
Right.
No, he.
Because it was favorable to you and you wanted to use it, and you said in your 3101D that you could, your expert would opine on trial testimony.
Right, and also contributing factors to causes
So it
of
was
death.
plaintiff who elicited that opinion
Right.
from Dr. Mukherjee.
That's correct.
Or
And
no,
that-
didn't it come out on cross?
Pardon?
Didn't that come out on cross?
It started on direct, and then it went right into the cross. He agreed that it could
Thank you,
happen.
Mr. Simone.
Thank you.
Mr. Shute?
Let me get to Judge Piggott's point about malpractice cases being a special breed and how this came about. Yes, they are special. One way they're special is that all the facts come from the defendant's employees or the records they made. That's why the doctor's called first. He's a fact witness. During the opening address at 103 of the record, defense counsel says, what we're expecting, people die of pneumonia, sometimes there's nothing you can do. During the direct examination of Dr. Mukherjee, plaintiff's counsel asks him at page 174 to 175 of the record, do you agree with the medical examiner that the number one cause of death is bronchopneumonia? And the answer is yes. Later, he's had a change of heart later in the case. And on cross-examination, he tells his counsel, well, I meant it was contributory in the sense it put him in the hospital where he got the heart attack. That's what I meant by it being the number one cause of death. Malpractice cases. This is what you deal with. You have a fourth-year resident who sees the patient at 6 p.m., who writes, patient is very hypoxic, and who takes the stand and says, I didn't mean very hypoxic then. I meant very hypoxic earlier.
This all was in front of the jury, right?
No, but the
All
point-
these arguments about this story changing and this coming out then, and these people, those are jury arguments. But what we're really concerned about here is when this judge makes this determination that they're going to allow this testimony, is it an abuse of discretion?
What I'm talking about, Judge, is a level playing field. That this is the way we start. And we have a rule about disclosure. And if we have an interpretation of that rule that penalizes those who play by the rules and rewards those who withhold information, then the playing field becomes even more unlevel than you start with.
What should they have included? What should this exchange have said?
It should have had reasonable detail as to the theory. Reasonable detail.
And
Now,
if it
in
didn't,
a-
shouldn't you have objected to that?
if there's, I think there's a theory there and there's not reasonable detail, I know to object. But if the theory's not even there, and they
What would
have
have
to
been the
object to that.
objection? Isn't that the objection, that there's no theory there?
Well, that's what I mean. That
But
was
you
the
can
objection.
see that. You can see that.
At page 7, it's 7 pages of discussion, the colloquy. And it's at pages 757 to 764 of the record, where the record doesn't show if counsel's being apoplectic or foaming at the mouth at the time. But he's pretty upset. And what he keeps on saying is, I had no idea, nothing about a heart
But
attack
he
until...
didn't ask, but let me ask you a different question. When you say reasonable detail, does that mean that they have to say here, the causation depends on X, Y, Z, and then specifically say an arrhythmia? Or do they have to say, causation testimony may not be limited to what the autopsy report concludes.
I think in this case, it would certainly have to be heart attack and or arrhythmia, and I think if the tables were turned and we were looking at the reasonable detail of a plaintiff's exchange, and the plaintiff's exchange said, well, they committed malpractice in some way or another, we'll let you know.
Mr. Shute, listen, my own personal Judge Fahey view is the response was inadequate to begin with. You had a chance to bring a motion, and you didn't bring the motion. It goes back to Judge Piggott's point, which is that the issue for us is that their response was clearly inadequate. You weren't timely. Can an untimely motion in this context be required, or is it an abuse of discretion? I think it really boils down to that.
Your Honor, I would commend to you the article by David Horowitz, which is cited.
I'm glad you didn't give me one of your articles anyway. That's good, that's good.
Who advises everyone now, in every case you get an exchange, to throw it back at them and not, so you don't have a waiver. May I have 1 second to address the second issue in the case?
30 seconds, sir.
Thank you, Your Honor. Mr. Simone said a couple of times that our expert could have also gotten the, quote, information that there was a heart attack. There's no information there was a heart attack. At page 804 to 805 of the record, their expert said there's nothing in the record about a heart attack. The proof that there was a heart attack was that their expert said there was a heart attack. And that should not be sufficient. It certainly isn't sufficient in Domes and all those cases. I'm an expert. I'm going to tell you what the cause is, and that's sufficient. There were specific reasons here to think it was not a heart attack. The medical examiner said bronchopneumonia. One lung weighs twice as much as the other, and he's been on a heart machine, a heart monitor, for 12 hours in the emergency room without any sign of arrhythmia, and the medical examiner finds nothing on autopsy, even though our expert said at pages 427 to 428 of the record, you'd find it in an autopsy. Now, how could something be more conclusory than I'm an expert, so I'm telling you it's a heart attack? Thank you, Your Honors.
Very welcome. Thank you, sir.